Although the Arizona Statute of Frauds under ARS Section 44101 generally requires that real estate contracts be in writing to be legally enforceable, there are specific exceptions recognized by Arizona courts where certain agreements may still be upheld, even if they were made orally. These exceptions arise from equitable principles designed to prevent injustice and ensure fairness when one party has relied on the oral agreement to their detriment. In real estate transactions, these limited circumstances are carefully evaluated by the courts to balance the intent of the statute of frauds, preventing fraud, with the broader goal of achieving justice when one party has acted in good faith based on a verbal promise. The most common exceptions to the statute of frauds in Arizona real estate law are partial performance, promissory estoppel, and admission of the agreement in court. These exceptions do not negate the statute but serve as equitable remedies that allow enforcement when strict application of the law would result in unjust outcomes. Each exception is narrowly applied and must be proven by clear and convincing evidence. The doctrine of partial performance is the most frequently recognized exception in real estate law. It allows an oral agreement involving real property to be enforced when one party has taken significant actions that clearly demonstrate the existence of a contract. According to Arizona case law, such as Owens versus M.I. Shep Limited Partnership, 2008, and Trollope versus Kerner, 1970. Partial performance may remove a contract from the statute of frauds if the actions taken are unequivocally referable to the agreement. This means the behavior of the party seeking enforcement must be so closely tied to the alleged agreement that it would make no sense absent the existence of the contract. Examples include a buyer taking possession of a property, making substantial improvements, or paying all or part of the purchase price. For instance, if a buyer orally agrees to purchase a parcel of land, moves onto the property, installs fencing, and builds structures, the court may determine that enforcing the oral agreement is necessary to avoid unfair harm, even though no written contract exists. Another recognized exception is promissory estoppel, which applies when one party makes a promise, and the other party reasonably relies on that promise to their detriment. In the context of real estate, this might occur when a seller verbally promises to sell property to a buyer, causing the buyer to incur significant expenses in reliance on that promise, such as paying for inspections, appraisals, or relocating based on the expectation of ownership. In Johnson versus Earnhardt's Gilbert Dodge, Incorporated, 2001, the Arizona Supreme Court reaffirmed that promissory estoppel may override the statute of frauds when it would be highly inequitable not to enforce the promise. However, the promise must be clear and definite, and the reliance must be substantial and reasonable. In real estate transactions, this doctrine is rarely applied and is considered an extraordinary remedy. A third situation in which an oral agreement may be enforced occurs when the party being charged admits the existence of the contract in court. Under this exception, if a defendant acknowledges during legal proceedings that an oral agreement existed, the purpose of the statute of frauds, to prevent fraudulent claims of agreements, no longer applies, because the existence of the contract is no longer in dispute. However, this exception does not apply if the defendant merely admits that negotiations took place. They must acknowledge that a binding agreement was formed. Certain short-term lease agreements may also fall outside the statute of frauds. Under ARS Section 44101, only leases exceeding 1 year are required to be in writing. Therefore, a month-to-month or 6-month residential lease agreement may be enforceable even if made verbally. For example, if a landlord verbally agrees to rent a property to a tenant for 6 months, and the tenant moves in and pays rent, the agreement is valid and enforceable despite being oral. It is crucial for real estate professionals to understand that these exceptions exist not to encourage oral agreements, but to prevent injustice when written documentation is absent. The Arizona Department of Real Estate ADRE, emphasizes the importance of reducing all real estate agreements to writing to comply with both the Statute of Frauds and Commissioner's Rule R4-28-1101, which requires licensees to act with reasonable care, honesty, and competence. A licensee who relies on verbal agreements rather than written documentation risks disciplinary action under ARS Section 322153 for failing to safeguard the interests of their clients or for unprofessional conduct. The Statute of Frauds remains a critical safeguard, but these equitable exceptions serve as a reminder that courts will look beyond technical formalities when fairness and justice demand it. The key for real estate professionals is to recognize the exceptions while always striving for full compliance by ensuring all agreements are properly documented and signed. Review Summary. While ARS Section 44101 generally requires written contracts for real estate transactions, Arizona courts recognize limited exceptions such as partial performance, promissory estoppel, and admission in court. Partial performance occurs when one party's actions clearly prove that a contract existed, such as taking possession or making improvements to a property. Promissory estoppel applies when a party makes a clear promise that another reasonably relies on to their detriment. Admissions in court can also validate an oral contract if the defendant acknowledges its existence. Additionally, short-term leases of 1 year or less do not need to be in writing under the statute. Despite these exceptions, brokers and agents must always document real estate transactions in writing to ensure compliance with law and ADRE regulations. Be protected. Make sure it is in writing. Discussion. What is the purpose of the partial performance exception to the Statute of Frauds? Answer. To prevent unfair harm when one party has acted in reliance on an oral agreement by taking actions that clearly demonstrate the existence of a contract. Under what circumstances might promissory estoppel make an oral real estate agreement enforceable? Answer. When one party makes a clear promise that another party reasonably relies on to their detriment, and it would be unjust not to enforce the promise. When is an oral lease enforceable under the Statute of Frauds? Answer. When the lease term is 1 year or less, as only leases longer than 1 year are required to be in writing under ARS Section 44101. Closing remarks. While the Statute of Frauds protects the integrity of real estate contracts by requiring them to be in writing, Arizona recognizes that equity sometimes demands flexibility. Courts may enforce oral agreements when fairness requires it, but these cases are rare and heavily dependent on proof. For licensees, the safest and most professional practice is always to document every agreement, ensuring compliance, protection, and clarity for all parties involved. Written contracts remain the gold standard for safeguarding the rights and interests of clients in every real estate transaction.